Okay, so civil liberties. Last time I think my federalism lecture went for like 45 minutes or something, a little long. Obviously, you can pause it if you've had enough federalism for one sitting, but still, I think I'll try to do this one a little bit. I'll break it up. So civil liberties, the first thing we'll look at is what are civil liberties in the incorporation doctrine, or the doctrine of incorporation. Extremely important in understanding how civil liberties, in particular the Bill of Rights, work now. And then First Amendment, and then the Defendant's Rights Amendments, and some of the, basically the rest of the Bill of Rights, okay? So civil liberties, here is one definition: the personal guarantees and freedoms that the federal government cannot abridge by law or judicial interpretation, okay? So whether it's a law passed by Congress or an executive order from the president or a judicial interpretation by the Supreme Court or another federal court, civil liberties, the idea is that they are personal guarantees, freedoms, protections from some sort of government interference, okay? The government cannot interfere with the freedom of the press or freedom of religion. The government cannot search your house without probable cause. There are all kinds of other things which we'll talk about in detail, right? So there are limitations on what the government can do, and no law, whether it's passed by Congress or whether it's an executive order, or no judicial decision can interfere with these or can try to take them away, okay? And of course, in the Constitution, we talked a little bit about the civil liberties that are in the main body, the original part of the Constitution. Some very important ones, habeas corpus, various other things that are important. But when we talk about civil liberties and when we're talking about them generally in American federal government, the real focus is the Bill of Rights, okay? So the Bill of Rights, the first 10 amendments to the Constitution, we know added at the insistence of the anti-federalists who thought that the original Constitution did not have enough protections for personal liberties, did not have enough civil liberty guarantees. Unlike most of the state constitutions at the time. We'll talk a little bit more about that in a second. Okay, so the Bill of Rights, those first 10 amendments were added to the Constitution. They are mainly concerned with individual rights, civil liberties, things like that, okay? So that's a definition of civil liberties. Does the Bill of Rights, I said earlier when I was defining civil liberties, I specified the federal government, okay? Does the Bill of Rights apply to the states? Does it limit state governments in the same way that it limits the national government? An early Supreme Court decision, Barron v. Baltimore, said no, okay? This was a case where the city of Baltimore had damaged somebody's property. So under the Fifth Amendment, which says that the government cannot take away or damage or somehow or other take away or damage your property without just compensation. So the person sued the city of Baltimore, and Baltimore said, we're not the federal government. The Bill of Rights applies to the federal government, not to the states, not to local government, municipalities. So we are not bound by that. We don't have to pay you back for your wharf that we damage. So it went to the Supreme Court, and the Supreme Court said, yeah, that's right, actually. The Bill of Rights, the federal Constitution, it's about the federal government. It's not necessarily about the states, okay? So first of all, remember the anti-federalists were convinced that the state governments would better protect individual liberties, all these things. You see, here's an early case, a lot of overlap between the Bill of Rights and what was the Bill of Rights that most state constitutions had. But here's one place where, federal constitution has something, the Maryland state constitution does not, just compensation if the government takes or damages your property. And the Supreme Court said, well, yeah, that does not apply then to the federal government. About 90 years later, there's another very important Supreme Court decision called Gitlow v. New York, okay? And it says, yes, the Bill of Rights does apply to the states. And this is the beginning of the incorporation doctrine, or the doctrine of incorporation, same thing. Okay, the incorporation doctrine basically says that the 14th Amendment incorporates the federal Bill of Rights into every single state constitution. So in practice, really simply what it means is that the federal Bill of Rights applies to the states. However, the incorporation doctrine, what they also said, they pronounced selective incorporation, which means that not just every amendment, but every individual right has to be incorporated by the Supreme Court, by a specific Supreme Court decision, one at a time. Okay, so Gitlow v. New York was 1925, but the right to counsel from the Sixth Amendment was not incorporated until 1963 by a Supreme Court decision called Gideon v. Wainwright. Others were even later. So there's incorporation, but it's selective incorporation, which means that each individual right, again, not just the First Amendment, but each individual right or civil liberty detailed in the First Amendment or the Fourth or the Sixth or whatever has to be incorporated by a specific decision. So it takes a lot of time, okay? What is the difference? The 14th Amendment, specifically says that every citizen of the United States government, of the federal or the national government, has certain rights that states cannot interfere with, okay? It's a relatively short statement, but the Supreme Court comes along in 1925, decades after the 14th Amendment was first ratified, and says what this means then is that those rights guaranteed to the state or guaranteed to citizens of the national government or the federal government in the Bill of Rights also limit the states, okay? So this is about the due process and things like that, okay? 14th Amendment, again, very important. We've already seen some of what it does with federalism, very important for civil liberties, very important for civil rights, as we'll talk about. Due process, first mentioned in the Fifth Amendment, but there's no mention of the states. Then the 14th Amendment says, again, every citizen of the national government has a certain fundamental right to due process of law, equal protection of the law, and no state can interfere with those rights, okay? Again, it takes a while for the Supreme Court to decide that what that means is, something like the Incorporation Doctrine. What it means is that segregation is unconstitutional, okay? But they eventually get there, okay? Due process, a very important concept for understanding civil liberties, okay? And there are two basic kinds of due process. One is procedural due process, okay? If you watch the old television show Law and Order, so often, the first half would be the police investigating a crime, and then the second half would be the trial. And oftentimes in the trial, it would come back to the way that the police handled a witness or evidence that they collected. When did they get it? Did they have a warrant? When the person answered this question, did they understand that they were, whatever? So that's procedural due process, a certain set of procedures that need to be followed in order to make sure that somebody is treated fairly. Okay, so very simple example, Miranda rights. Once you're placed under arrest, the police have to tell you, you have the right to remain silent, you have the right to an attorney, you have to understand that if you say things that may very well be used against you in your trial, and if you can't afford an attorney to help you answer these questions, to understand what is illegal and legal and what you can and should and shouldn't say, the state will provide one for you. So you have to tell them those things. If you arrest somebody and you don't tell them those things, you don't give them or read them their Miranda rights, and they confess to the crime, that confession is inadmissible, okay? It doesn't matter if they actually say, yes, I did it, procedural due process has been violated. Okay, that due process guarantee that they have of protection from being, questioned when they're under arrest without understanding that they have a constitutional right not to speak, and that they have a constitutional right to have an attorney there to help them, and that if they can't afford one will be provided. If they are not informed of those things, anything they say is inadmissible in court, okay? That's procedural due process. It might be much more complicated, things about how evidence is handled, but procedural due process is just the process, the way that, say, somebody is investigated and the way that they are treated when they're being investigated and arrested, okay? Usually applies especially in criminal cases. There is also a concept of substantive due process. And this basically says that there's a fundamental problem with the law itself, okay? Segregation is a good example. The legally mandated separation of the races in public places, okay? The notion there is that it violates certain, to use the language from the Supreme Court decision in Gitlow, it violates certain fundamental personal rights and liberties that are protected by the 14th Amendment, okay? So substantive due process, the issue isn't how was the person prosecuted, what happened when they broke this law. The problem is the law itself is fundamentally wrong. The substance of the law violates that 14th Amendment guarantee of due process, okay, of equal protection of the law, these fundamental personal rights and liberties, okay? So the 14th Amendment really changes the Constitution in very important ways, and it really makes a lot of important protections for civil liberties much more real, because again, until that happened and until those things were fully incorporated, lots of states did not have nearly as many protections for individual rights as that federal Constitution did, okay? So Civil liberties, what are they? Limitations on the government, protections for personal freedoms, personal liberties. Do they apply to the states? Not originally, but yes, they do now as a result of the Supreme Court decision Gitlow v. New York, which first enunciates the Incorporation Doctrine. And the basis for the Incorporation Doctrine is the 14th Amendment, which says that all citizens of the national government have certain fundamental personal rights and liberties that no state can interfere with. Okay, so that is the beginning and the kind of the basic overview of civil liberties, what they are, and the Incorporation Doctrine.